Hello everyone, myself Prashant Tyagi from team LEXIS and Company. I hope you all guys are safe and healthy. Today in this video, I am going to discuss about the topic copyright and design protection. What is copyright and design protection means? Let's start our video. The law gives protection to fashion designs under two types of intellectual property, specifically copyright and designs. The role of intellectual property right in the fashion industry is very complex. There is still ambiguity about how fashion designers should reach out to the law for the protection of their designs. The area of law commonly creates confusion in the minds of people and does not effectively protect fashion designs. In the fashion industry, one will often come across the fashion term fashion piracy, which is an unauthorized and illegal reproduction of copying of an already made design. Fashion piracy generally holds and includes two meanings: knockoffs and counterfeits. A knockoff is said to be a close copy of the original creation which is sold under a different label. A counterfeit is the exact copy of the original fashion design and it is sold under the same label as the original, which is also called a fake product. To protect designs from such knockoffs and counterfeits, the industry resorts to intellectual property protection. The law gives protection to fashion designs under two types of intellectual property, specifically copyrights and designs. There is a very thin line difference between the protection granted by copyrights and design. When it comes to artistic work in India, however, the laws have been made fairly easy. To determine the difference between the two kinds of protection in India, the copyright protection is governed by the Copyright Act 1957 and Designs Protected Act 2000. Copyright gives protection to creative works which may be literacy, artistic, educational, musical form, etc. Artistic work generally includes paintings, photographs, jewelry designs, fashion designs, etc. Designs as defined under the Designs Act is considerable external feature such as the shape, configuration, pattern, ornament, etc., which has been applied to any article through industrial process that can be seen on any article and that can be determined only by the eye. One major difference between the two forms of intellectual property is that protection under copyright is only from the exact that the original article is created. However, the Designs Act only gives protection to an article when the owner gets the design registered. This makes a copyright an inherent act and registers designs a statutory right. Designs need to be original and expressed in a material form to gain protection. The expression will generally be considered only if it is not a copy of the something. Fashion designs can gain protection under copyright law if they fall under the purview of artistic work. Designs that can be registered under the Designs Act 2000, they are registered, only get protection under Designs Act. Designs which are not registered may receive only copyright protection. In particular, designs that cannot be registered under Designs Act because their original artistic work get protection under Copyright Act. It should be noted that the dual protection can only apply to these designs. Section 15 of the Copyright Act explicitly permits. The dual protection can be lost in two ways. Once the design is granted registration, the owner forgoes the protection he originally had under the copyright law. This has been provided under Section 15, subsection 1 of the Act. When there is a copyright of an unregistered design, such copyright ceases to exist the moment the article on which the design is applied has been reproduced by an industrial process more than 50 times as per the Section 15, subsection 2. The art applied to an article given aesthetic appeal and the moment more than 50 pieces of that article are sold. the artwork loses its place under the copyright law and the production it extend and come under the ambit of design law. In most situations, designers refrain from registering their fashion designs due to the dynamic nature of the industry. Once registered, a design is protected for 10 years and the overall visual appearance of the article is protected. The Design Act prevents anyone other than an owner from replicating the product as well as creating articles with similar designs to the registered design. If after observer how the general public reacts to the fashion design, the creator feels that his or her design is here to stay for years to come and will be sold in large numbers, they should consider opting for design registration under Design Act to protect their creations. The conclusion of all above discussed theory is that you have to register your design, patent, your artistic work, your ornament, jewelry under the Copyright Act and the Design Protection Act to ensure the safety of the counterfeit of your design. I hope you understand the design and the protection in fashion industry. Thank you so much. Stay safe, stay tuned. Have a nice day.